Of course, that's what I said.
I was voted the fourth best looking bald attorney in Grand Rapids.
You're that far down the list?
Mary Benedict said I was third. So that was, she really defended me on that one.
Congratulations. I'll talk to my sister. I think she's got you higher than that. So, all right. We're here in the matter of Otera versus Hunter. We have present the defendant, Mr. Hunter, with his attorney, Mr. Cox. We do not have Miss Otera Earl. And are you expecting her here, Mr. Cox, or do you know anything at all?
Your Honor, yes, we had a development. I received a letter from her. I did not talk to her. I've never talked to her myself. But I did forward that to the prosecuting attorneys indicating she wanted to relinquish her parental rights. So it's a fairly lengthy letter, but I don't know how to deal with it. I just want to make sure the court's aware. And again, I did provide that to the prosecuting attorney.
All right. Well, then maybe I should indicate that Mr. Rummelt is here from the prosecutor's office, and I'll turn it over to her for any statement she has.
Thank you. I actually did speak to Ms. Otero yesterday regarding this letter that we received. She did indicate that she would be here this morning, but she is not. I'm requesting that the court enter a judgment of support and uniform child support.
I'm sorry, everybody. I didn't mean to interrupt you. Apparently, need to be checked for dementia. She is here in my office. I did not know that was you. I apologized. I thought this was another family member.
All right.
All right.
If you good.
I'm sorry. Can we grab your chair over here? I did not know that was you. You guys want to hear? Actually, why don't you guys switch over here and I'll go on the end here because I'm loud enough as it is here. Why don't we have you sit there? Nobody has trouble hearing me ever.
All right. So now everybody's present here.
I guess the whole family.
Mr. Cox, who is here representing the defendant. Ms. Rummelt, this is your motion to enter a judgment of support. You have asked for a deviation due to basically the parties agree that the father makes up the substantial assistance with childcare, and so really the only thing you're trying to do is enter the medical part, if you will, the $25 ordinary medical, because apparently mother is probably on state Medicaid.
Yes, there has been a lot of developments over a very short period of time in this case. I did run child support based on parties' actual incomes. They were given credit for equal parenting time because father was doing a lot of the daycare. Mother was going through some health issues, and the child has apparently moved to live full-time with dad right now. I contacted DHHS, and it does appear that the child has been removed from mother's grant, and she is only receiving Medicaid for herself, no benefits for the child. And so I would be happy to enter a zero support order. But because mother has the initial custody by virtue of the affidavit of parentage that the party signed, I do think it would be appropriate to send this to friend of the court for a parenting time and custody mediation. It does sound like it's the party's desire that the minor child remain in father's care, that he needs an order to that effect, or we're going to be back here, again and again, because DHHS and the state of Michigan think that mom has custody. So I do think that unless Mr. Cox has some sort of consent order in the works, that would be appropriate. Thank you.
Mr. Cox, are you going to have an order from the parties, a stipulation maybe that dad will have custody?
Yes, Your Honor, we can get that together, no problem.
Okay, so he will assume physical and legal custody, it sounds like then.
Yes.
Then why don't we adjourn this for 2 weeks and see if that can be done so that we don't just enter an order that's meaningless and everything. So would that work with you? And that would give you a chance then to enter a stipulation between mother and father and get it to me. We can put this off for 2 or 4 weeks to make sure that, why don't we do it for 4 weeks so that we're sure that we can get whatever's going to happen done and get it to Miss Rummelt so that she can deal appropriate with it. Then maybe we can get rid of any problems in this case. Would that be all right with you, Miss Rummelt?
It would be.
Mr. Cox, would that be work for you too?
Certainly, Your Honor. If I just could ask Ms. Rummelt, do you prefer to do the judgment of support separate, and then I do a custody and parenting time order differently or separately, I should say?
Yes, I will resubmit my judgment of support with the renoticed motion. It looks like we'll be doing it November 17th. Does that sound right?
Yes.
And then I will, I think it's paragraph 8 and 9, the custody and parenting time, I will just simply refer to the separate order to be entered contemporaneously. Does that sound good?
Sounds good. Thank you very much.
Yeah, the two of you, Miss Oscaro, are you following what's going on? You're all right with this adjournment and everything to get things taken care of?
Yes, sir.
All right. Then we'll adjourn this and we'll see everybody's smiling face here about 4 weeks from now or something. And hopefully everything will be working out. All right. I see the child apparently is there and looks happy. So good luck, everyone. Take care. And we're adjourned. Thank you.
Thanks.
3
Have a great
kids.
weekend.
Thank you.
There's a request that says there are 24 overnights, actual income from the parties. Is that pretty much state what you want, Ms. Brower?
Well, yes, Your Honor. Just to go back to what happened at the pre-hearing conference, the defendant works at a place called Sunseekers Demolition. He stated that he earns $18 an hour at 40 hours per week and that he works overtime. I asked him to provide me with proof of income, and I've never seen it because he didn't provide it. The information I have shows that he actually grosses $9,417.32 per month. And again, I never got proof of income from him. I used the mother's actual income, let's see, which is $20 an hour at 35 hours per week. And I do see that I left off an effective date off of the uniform child support order. If the court just wants to make the effective date October the 1st, that would be fine.
Yeah. Okay. All right. To Ms. Lopez, do you have anything you wish to say about this order? Ma'am?
Myself, I'm sorry. I wasn't sure if you're talking to me or
you first.
No, I mean, I just, when we went through the first time, I mean, I was fine with it. I didn't know exactly the amount that he was making. I mean, it is a difference. We just wanted the court to be able to make that decision of what's fair.
All right. Ms. Brower, I take it you got his income through the state and through the employer or something, since he never provided it to you?
Your Honor, I am unable to indicate the source for that income information that I used for him, but this is what I found.
Okay. Yeah. You are okay with the source of what you got it from? You believe it?
Sure, definitely.
Mm-hmm. All right. All right, Mr. Lopez, anything you want to say?
No, pues, if that's what she thinks, it's fine. I mean, right now I've been working, but right now I haven't been employed since last week Wednesday because there's no work right now. So right now I'm looking for a job, but I mean, the decision comes up to you,
Well, it was based on the money that you were making at the time. And
yeah.
if you find that you are unemployed, you need to file a motion to suspend or to relook at it. But at this point, it appears that it is appropriate because they've been able to find through sources that was the amount that you were making. So I'll enter the order as is requested. And Mr. Lopez, if you are unemployed or you become unemployed, you simply need to request maybe a review of your child support. It doesn't even start until, well, it started how many days ago ever we had it, but I will start right. Effective on October 1 of 23. All right. Good luck, everyone. What?
Yes, it makes sense.
Okay. Thank you all very much. Thank you. President. We also have from the prosecutor's office, Tracy Brower. This is her request to enter a judgment of paternity as well as a UCSO for support. I can start out by saying that there is a order of affiliation in the file that the parties had agreed to. So I don't know if there really needs to be that judgment of paternity that still would require. There was a stipulated order of affiliation on 8/22/23. So I don't know that we really need the judgment of paternity. That's correct, isn't it, Ms. Van Dyken?
That is correct, Your Honor.
Mr. Mahone, you do agree that everybody agreed that you are the legal father, right?
Yes, Your Honor.
All right. But as far as a UCSO, they have income actual from father. I believe mother has some SSD or something like that used for her income.
That's correct, Your Honor. The mother receives SSD as well as long-term disability.
And that was calculated in her support.
Yes, that's correct.
Ms. Van Dyken, anything you want to say about the order at this time?
I would just agree we don't need to enter the judgment of paternity order, just the uniform child support order at this time.
Okay, and you agree with the uniform child support, I assume?
Correct.
Mr. Mahone, anything you would like to say regarding, we don't need to enter the judgment of paternity, but we do need to enter a child support order. Is there anything you wish to say about the child support order?
Yes, Your Honor. I spoke with Ms. Tracy a few weeks back, and she informed me that the amount that I would have to pay is $621 a month, but it was based on, at the time I was working overtime, in which I'm not working overtime anymore. And I sent the letter to my employer sent the letter to Mrs. Tracy not too long ago about me not working overtime anymore and how I'll be only working 40 hours a week based on now that we have a sufficient amount of employees.
Your Honor, when I ran guidelines using the father's actual income. He provided me with his 4 most recent pay stubs, and that's what this child support amount is based on. He earns an average gross income every other week of $1,756.14, which would be a total of $3,819.60 per month gross. The defendant does not have any overnights with the minor child. I did speak to the defendant on August 31st, 2023. He told me that he is now earning $16 an hour. This child support recommendation is based on him earning $15 an hour times $15 an hour is what he was earning when I calculated support. And it is based on, like I said, me averaging his 4 pay stubs, which do include overtime. So I told him, I said, if you're not working overtime anymore, please provide me with your couple most recent pay stubs or either a letter from your employer indicating that you no longer work overtime. And I've never received either. I've never received more pay stubs from him, nor have I received a letter from an employer indicating that he is no longer working overtime. So this recommendation is based on the 4 most recent pay stubs that he provided me. So that's what the calculation is based on. And I'm asking that the court enter it.
If I may speak, Your Honor, I have a tracking number from the U.S. Postal Service that says that it was delivered on actually Wednesday of this week, a couple days ago.
I physically have not received it.
I also emailed it, like you asked, Ms. Tracy. You said enter my car ID in the email, and I entered it before that.
Okay. Yeah, I haven't received it.
If I may, Your Honor, I also asked Ms. Brower to ask about his second job at the cell phone store. I don't think that was incorporated into.
Yeah, I don't work there anymore. I haven't worked there in a while.
And Ms. Van Dyken, I did send you an email that I did inquire of the defendant as to whether or not he had a second job, and he told me what he's saying now. He stated that he no longer has that second job.
So at a minimum, if you took him back to 40 hours, but it would be at $16, not $15.
Correct,
right?
At the minimum.
And Your Honor, I will also see if there's a way that I can have Lila put on my health insurance through my employer. I have Blue Cross Blue Shield. I know that does affect it as well.
Well,
child's already covered by my client's Medicaid, Your Honor, with the disability.
Well, he's going to be ordered to keep health insurance on the minor child as long as it costs him no more than 6% of his gross income. And if and when that happens, he can file a motion to ask for a review of child support to reduce what would be base support. But likely it's not going to be a huge reduction.
Yeah, Your Honor, I can't afford $621 a month, especially with me not working overtime anymore. Like that's almost my rent. I literally wouldn't be able to live or do anything else. I wouldn't be able to work. I wouldn't be able to afford a house to live. Like
I'm not going to go any farther with that because child support is based on incomes, number of overnights. Your overnights will increase, I believe, in the future, and it can be recalculated based on that. But child support is based, it doesn't count rent, it doesn't count car payments, it doesn't count anything like that. It is a formula through the state of Michigan that says this is how much you pay in child support. Now go live on what is the rest of it that you have. And unless there is some significant deviation, which there isn't here, then that's the way I have to provide it. Do you know what, Ms. Brower, do you have any idea from calculating if we did do him at 40 hours a week times $16 an hour, if it would make much difference? I mean, I have no idea.
Yeah, no problem. I've already calculated. So keeping mom's income the same and using his income as $16 an hour at 40 hours per week, the total child support recommendation comes out to be $487 per month.
Right. Ms. Van Dyken?
I would object, Your Honor. It's clear Mr. Mahoney is just quitting jobs and reducing his hours based upon child support.
Well, what I'm going to do is enter the order that has been presented to me by the prosecutor's office. Sir, I'm going to tell you this. If your incomes are changing, if you do put your child on your insurance, which is the right thing to do, if you start getting some overnights and things like that, simply bring a motion and I will probably have the friend of the court relook at what is appropriate. The only information that Ms. Brower has of now is what would be appropriate for this order. And so I'm gonna, when was the start date on this, the effective date, Ms. Brower?
September 1st.
Yes.
September 1st. We'll leave it at September 1st, and I will leave it up to you, Mr. Mahone, to follow through. Make sure that you should provide maybe Ms. Van Dyken, since Ms. Brower will be out of this now, okay? Provide Ms. Van Dyken with recent pay stubs. Talk to her about whether or not we can recalculate or something along that lines, because she's going to have to see this kind of stuff. And then you can always come back in and I can listen to a proper motion based on it. I'm just going to enter based on what Ms. Brower has to date, and I think that's appropriate, and we will move on from there. So I will enter the order as has been presented to me and look for if things are appropriate in the future, we'll deal with it. All right. Thank you.
Your Honor.
What?
Your Honor, if may I say something, please?
Briefly, I got a lot of these today.
Okay. I have no problem paying child support. You know, I initially put myself in this position. I started the case for child support and everything. I have no problem providing for my daughter, but I feel like that is an egregious amount, and I can't afford to pay that, especially with me not working overtime. We were short staffed at the time.
I just found what I have. I've told you how you can have it reviewed if necessary. If you can show that you clearly don't make that much or whatever. But Ms. Brower, all the information that she has indicates that that is appropriate. I'm not going to change it right here, right now. So it can be changed in the future. Child support can always be changed. It's up to you to make appropriate motions and or whatever to see if it can be, and deal with Ms. Van Dyken on it. She is not hard to deal with. Maybe show her that maybe you make less and you'd like to have it reviewed or something. And you can always bring a motion. But at this point, Ms. Brower's waited long enough. She is the information that you provided to her show that this is what is appropriate. Good luck, everyone. Thank you.
Thank you, Your Honor.
Both parties are present, and so is Mr. Block, who is representing the defendant.
Las dos partes están presentes y también está el señor Black, que está representando a la demandada.
This is father's plaintiff's motion for change of custody. The judgment gave primary physical custody to the mother in the judgment based back in November of 2020. Mr. Reyes has indicated that her boyfriend that she is living with has hit the kids and touched the daughter inappropriately. CPS has apparently been involved, and that since June, the children have been taken by father and have not really been able to see the mother. So you can literally change the children's school, which according to the rules of joint legal custody, he needed to also discuss with the mother. It's my, Mr. Block, I did receive your response. And Mr. Reyes, what have you got to say?
Bien.
Okay, what happens, what I want is that my kids to be well.
As do I.
Y yo también.
And does the mother.
Y también así quiere la madre. If this hadn't happened,
yo no se los haya peleado.
I wouldn't have fought for them or but with them. But it happened one time already.
¿No
When her brother's boyfriend hit them.
Le pegó a Citlali.
Hit Citlali. And the attorney won the case. And they stayed with her.
All right, but why hasn't she been able to see the kids since June?
Because they don't want to see her.
Están asustados.
They're frightened. They're frightened. They're afraid.
Y no quieren verla.
And they don't want to see her.
So if your kids say they don't want to go to school, they get a chance to do that?
No.
No.
No, but they can say if they want to go see the mom or not.
But
si tienen miedo.
If they're afraid of, and they're afraid that the same thing would happen if he rapes Daniela.
Miss Flores didn't do anything to your kids.
But she let her husband or her boyfriend do it.
All right, Mr. Block.
Senor Black.
Thank you. I did get this answer over to Francisco via email last.
Gracias.
I don't know, it was like 5 o'clock yesterday. I had called him and got his email, so he has had it. Defendant mother is absolutely ready and willing to have the children over at her aunt's house. Aunt.
La tía, en la casa de su tía. Sorry.
And my client has been 100% cooperative with CPS. CPS doesn't want these kids at the house either, so the kids will not be at the house. What you have here, unfortunately,
aquí, desafortunadamente,
I just barely got involved, but dad is just simply alienating these kids, and mother needs to see them.
I agree.
Estoy de acuerdo.
As soon as possible. I realized, and as I put in the motion, and this isn't my motion, but I think the court does have authority to do something.
Make some changes here.
I'd like to see immediate parenting time. I don't know as far as whether you think a troubleshooting meeting would be helpful?
¿Resolver los problemas o no?
I'm going to set some parameters here in some time. Okay? Is your client still living with this guy?
She is presently. She is desperately trying to. She's working. She picked up a second job, I think, at Amazon. She intends to move as soon as possible.
Well, whether she moves or not, is she still going to be in a relationship with this guy?
No.
No.
Sí,
yes,
señor.
Yes, sir.
Oh,
she will not.
Ella no lo va a hacer.
Yo digo que sí.
I say yes, she'll do it.
Well, I don't know, Mr. Reyes, that you know what she's going to do. It appears at this point
Parece a este punto
that there is proper cause or change of circumstance, warrant an evidentiary hearing regarding custody and parenting time. I don't know whether it will prove that this was just a temporary thing that she got out of. We'll leave that to the evidentiary hearing, of which everybody will get notice. In the meantime, Mr. Block has put forth that his client will take the children to an appropriate relative's home.
Okay.
And we will also put in the order, Mr. Block, that the perpetrator's name, I don't know what his name is, they have no contact with the children at all.
And I believe that she knew what her boyfriend was trying to do anything.
Y por eso pasó eso.
And that's why that happened.
That'll be for our evidentiary hearing. There is nothing to indicate, to me at least, that she allowed this to happen. But we'll find out at the evidentiary hearing. In the meantime, she's going to be allowed every other weekend with the children. Can she do that, Mr. Block?
Yes.
See?
And she has an appropriate place that is not at that residence.
Yes, she would take them to her aunt's house.
¿De cuál tía? ¿De cuál tía?
What aunt?
Veronice.
So she is suffering, Angelica is suffering violence. He hits her. And her sisters wanted to call several times, but she doesn't understand. And
está enojada con sus hermanas porque me ayudaron.
And she's angry with her sisters because they helped me with the children. Rosa, my sister-in-law, nobody's going to take care of them better than she. But because she's angry with her, because she doesn't want them to be with her, but nobody's going to take care of them better than her Aunt Rosa. But because she's angry with Rosa, sent some girls
a que golpearan a Rosa y a quitarme los niños.
To beat up Rosa and to take the kids away from me. Rosa didn't come out.
De Rosa.
It's all filmed at a camera by a camera at Rosa's house. But nobody's going to take care of them better than she will. She just does it because she's angry.
Le queremos salvar a los niños.
We want to save the children. It happened once already, and he won once already. And what happened that they hit the children?
Can I interject here, Judge?
¿Puedo imponerme o interrumpir aquí, señor juez?
I can only listen to so much of this. I think he's making my point.
Creo que él hace mi punto.
To have Rosa, Angelica's sister, raise the kids. He's not going to follow this court's order, is my suspicion.
And if he doesn't, you'll file something with the front of the court or an order to show cause.
Can I put in the order that he be absolutely enjoined and refrain from alienating these kids from their mother?
You can put it in there, but I don't know what it does.
What if the children are afraid?
Los niños no la quieren ver, tienen miedo de que les vuelva a pasar lo mismo.
The children don't want to see her. They're afraid that the same thing will happen again.
Hold on.
Espere.
There's no reason to believe it's going to happen because it happened from her boyfriend.
No.
So you see to it that the kids see the mother this weekend. It will be Saturday morning at 10 a.m. until Sunday at 5. After that, it will be every other weekend, Friday at 5 till Sunday. The kids are to have absolutely no contact with this perpetrator of the violence, and I want that person's name in the order. Ma'am, that means you will not have telephone contact when you're with the kids and this kind of stuff with him. When you have the kids, you'll be with the kids and not with Luis. They will not be subject to being around him, hearing him, seeing him, or anything, all right? You will also have every Wednesday from after school until 8 o'clock at night where you can see the children. Again, you can go out to dinner with them. You can go to your aunt's or whatever it is. Doesn't matter. Luis is not to be around. You understand? Mr. Reyes, you will make sure that the order is followed. We will set an evidentiary hearing to look at the possibility of changing custody to Mr. Reyes. Mr. Block, if you'll get that order to me, you get it to me today, I'll sign it. Otherwise, send it through 7 days.
One question: how is my client going to be picking up then from his house and dropping off at his house? Or I mean, that's fine with me. I just wanted some direction. I don't think the parties talk very much. So,
is there a neutral place that we could go, the police department or something?
How about the Wyoming Police Department?
Yeah, that will work.
Si esto funciona.
On the Wednesdays, she can pick up the kids from school, and they can meet at 8 o'clock at the Wyoming Police Department. Mr. Reyes, you'll get a chance to put on all your evidence and see whether or not we should change custody to you as soon as we can have a hearing. That is the order of the court.
Esa es la orden judicial.
Good luck to both of you. Thank you.
Buena suerte a los dos de ustedes. Gracias.
There will be an exchange at the Wyoming Police Department on this Saturday at 10 o'clock.
Are the kids going to stay with me, or are they going to go with?
They're going with her from Saturday through Sunday. Then they're coming back to you. The only time she sees them is during the parenting time that I've ordered, and then we'll determine the rest at the hearing.
Y luego vamos a determinar lo demás en la audiencia.
Thank you. Sorry, sir.
Gracias.
I don't know how to pronounce your last name.
Thanks, Judge.
Gracias, juez.
I'm sorry? New joke. All right. How did you give her notice of this? Through the mail? More than a couple weeks ago or whatever? All right. This is the defendant's notice or request for child support. Basically, he disagrees with the order that was entered by this court on 7/28/23. Says he works more at times and less at other times. Friend of the court calculated his support based on that he works the same all the time. Sir, I looked through the front of the court report, and they simply did not. They took your average of the first 4 months of this year, averaged it, and came up with an amount that came from them. I believe, I don't know whether or not they got that from your employer, but I can find out. They received that information, and it says the employer and pay stubs verified 2023 gross earnings of $22,920 for 16 weeks. They averaged everything out. Why? What's wrong with that?
Your Honor, the average, I don't understand what you mean by the average, because I work hourly.
Yeah.
Okay. Some weeks you don't get overtime.
Right.
Some weeks you get overtime.
Right.
Okay. Now I have only a daughter with her. If he increased or she increased my child support to that amount, what about the months? I don't work that, I don't have overtime.
Because that's what I'm telling you is they look at it and they take your 4 or 5 months at a time and say, yes, sometimes you work overtime, sometimes you don't. They take all of the money that you make over 4 months and make it so that, okay, sometimes he works more, sometimes he doesn't. So at those times that you make more, you're getting a break. At times that you make less, you don't. All they said is they received 16 weeks worth of time. All right, 16 weeks worth of pay. And that's what they averaged it out. So sometimes you made more, sometimes you made less.
Okay, Your Honor, apart from my child support, I know you might, I don't know if you're gonna consider this. Apart from my child support, Your Honor, I do every other thing for my daughter. Apart from my child support, I give another 160 to 180 a month for her lunch at school. School supply is on me. School clothes is on me. Street clothes is on me. Sometimes they don't have food at home. My daughter will call me. I'll take her to the store.
Here's what child support is for. Okay, you pay your child support. If you pay other stuff, I mean, the friend of the court can't get involved in saying, okay, you paid $100 this week for your child's clothes. Okay, they aren't going to subtract that. You owe child support according to the state of Michigan and how they run it through the computer. You owe child support. If you wish to also help, that's great. That's what every father who's any good does. I don't know what else. There is nothing in here that would indicate that the order is incorrect. And as such, I'm going to deny your request for a change of child support. What you do beyond that is up to you. That's between you and the mom and the child and all that kind of stuff. But we are not going to get involved in your daily, whether you buy her lunch or whether you buy her school clothes or books or whatever. That's not what the friend of the court can't even get involved in that. We can't.
If I'm paying child support, I understand what you're saying, but if I'm paying child support and she's not doing all this that she's supposed to use the child support to do, and my daughter is coming to me, what do I do? Do I have to say no?
That's up to you. What am I supposed to do? Change your child support? Because I don't know how much you're going to pay. Or I don't know if he'll deny it. We can't get involved in micromanaging this. So your request that you disagreed with the order, I'm denying it at this time.
Can I get two overnights a month? If that's gonna,
I can't. That's not before me. I can't rule on that. It's not. There's nothing here about your parenting time. This is strictly child support. You have to give separate notice and you have to go through altogether different things to determine that. It's the rules that I got to play by and that you got to play by. So I'm not going to order any change in parenting time whatsoever because that's not before me. And she would even have no notice of this. So your motion is respectfully denied. There are a couple motions here. The primary one I begin with is the motion filed by the plaintiff mother regarding seeking a change of custody and child support, but change of legal and physical custody. Ms. Quist, I read your volumes of information. Some of it is completely irrelevant, but some of it's appropriate. What have you to say in your request for? All I can do is give you an evidentiary hearing anyhow.
I was going to say, Your Honor, we have a substantiated CPS case and we have a criminal prosecution that is ongoing and there's a no contact order between Mr. Feldkamp and the boys. We have met threshold in this case. I would like to state that I do have the case by Barca with me. Change of circumstances is relegated to the last custody order, but only for meeting threshold. Following that, and I can read the case, for comparison purposes, it all comes in. Proper cause under.
We're not going to get into that at this point because obviously
okay, that's fine.
I'll give Mr. Haskell a moment, but I can't imagine how that being charged with child abuse, a finding of preponderance through CPS, as well as a bond that doesn't even allow him to have contact with at least one of the kids, does not provide Vedvarka. Mr. Haskell?
No, I think threshold is met, Your Honor. My main concern is limiting the cumulative evidence. We've got.
We'll deal with that when we come up towards the hearing. We'll certainly have a hearing. All of us, meaning you and Ms. Quist, will certainly have a hearing or a settlement conference or a status conference before we have the actual hearing to determine what is or is not. I'm not going to make a ruling now on what is or is not appropriate at that evidentiary hearing. There's ways to get to that.
Okay.
All right. Clearly, there's Vedvarka, and I'll be setting an evidentiary hearing for change of custody.
Your Honor, with regard to that, can I have a little input on when? I think there is.
Your office will be called. I mean, my clerk will call both of the attorneys to see if they.
Okay, sure.
Time. I mean, I'll give you a warning. She usually calls and tries to set it up with both parties and does about 2 times, and then if just can't, then we eventually set it because we can't go on forever. But she will.
There's one already on the calendar.
Well, there is I think there's something on the calendar regarding the. Is that regarding the ex parte?
Yes, Your Honor.
That's a hearing regarding the ex parte that
Yes,
I'm going to have to.
Yeah, but there's an evidentiary hearing scheduled for December 4th on this matter, and that date does not work.
Does not work.
Not for one of our witnesses, no. That's what I was hoping to give some input on. If we could do it in November or late December, it would work better.
We're booking out hearings till February.
Oh, I see.
So I will, if you have a problem with one of your witnesses or something, I'll give you the right to bring them in through Zoom, because otherwise these hearings are going to be in court. Okay, they're going to be in person.
Understood.
And I'll give you the opportunity, unless Ms. Quist objects, but even if she does, I probably am going to allow some of those, if it's appropriate, to allow a witness to testify via Zoom. I would hope that would help you some.
Probably not, Your Honor. The witness will be on our honeymoon.
And she doesn't want to be in a hearing on that?
No, sir. I don't think so. Not during her honeymoon.
Is she going somewhere warm and tropical? Could she maybe Zoom in from a beach somewhere so that we can at least get that?
Well, I mean, I'm being told by my clerk that we've only got like 2 or 3 hours. Are we going to be able to get through the whole thing then anyhow?
No.
Not a chance.
Well, then we'll start it and see what we can do, and we'll start looking for another date for everybody everywhere for the evidentiary hearings for this, as well as the order. We're getting dates now, which are we gonna, is it best to just set a hearing and start the whole matter? Or should we do this to set aside the ex parte of Judge Hillary? That's what my understanding was. That's the December hearing. Is to set.
That was my understanding. The December hearing was about the ex parte, Your Honor.
Well, I've actually noticed the objection to the ex parte and to change it for October 20th. I didn't know that Mr. Feldkamp was going to be in town today, so I set that out a couple of weeks ahead. It's on the calendar.
It's on the calendar, but it's not an evidentiary hearing. It is is a motion. Okay.
Yes, it's a motion.
So and I can, and this doesn't take a genius to figure out that the two of you are going to fight about this. Okay, and there's going to be evidentiary issues.
Oh, I see where you're going. Yeah.
All it'll do is set up, and my clerk tried to grab some time right away so that we could do something on the request to set aside the ex parte.
Sure.
But I'm wondering if we shouldn't loop all of this into one and move forward with that, because we got other times that I can find for you right now. What were you saying on the first one?
The first one I've already sent out to
somebody else.
Somebody else. But
February 5, 9 o'clock.
Well, if we can hear the objection to the ex parte, we have that December 4th date, and then we can continue. Is that what the idea is, Your Honor? Taking the motion off of the calendar for October 20th, then beginning the evidentiary hearing on December 4th?
But the evidentiary hearing, as I understand it, for December 4 is simply to set aside the ex parte.
Okay.
That's what we set it for, because I hadn't even ruled on this, that there was clearly Vatvarka. And so we got to set up evidentiary hearing for change of custody. All right. And we're not, I mean, I'm going to tell both parties right now, we're not going to turn this into a 4-week, matter. If need be, when I have a status conference, and I can have a status conference fairly soon so we can talk about where we're going on this thing. But I'm going to limit time if I have to. I'm not going to just let this go on and on and on and on with going back to, 2015 and everything in between and all that kind of stuff. We're going to have to get to some type of resolution. Does the 5th, February 5th, looks like I have morning and afternoon.
Why don't we book both?
I hate to give both of them to you, but if you both can do all day.
I can.
Yes, Your Honor. I might be on.
All right.
Okay. I'm supposed to be.
We'll send out notice to both of you. I'll give you that day, and I'll also keep the December date, and we'll figure out what we're going to do with that. All right, what we're going to start or whatever, because everything's overlapping anyhow. I mean, the ex parte is such a part of this whole hearing that I'm wondering if we should just start everything at one time. But if you want to get to the ex parte evidentiary hearing, we can get to it, but we're only going to have a couple hours, and I don't know if that's going to take care of it. So that having been said, there's an evidentiary hearing set regarding custody, and it's set for February 5, both morning and afternoon. All right.
Okay.
I note that I did see that you have an objection to the ex parte that was set for the 20th. It was set for the 20th. I don't know what, I mean, we've already set up an evidentiary hearing to set aside that.
Well, if you're saying it's going to evidentiary hearing regardless, then we can take that off calendar.
Well, Ms. Quist, I assume you're going to oppose it, and we're going to have a some evidentiary issues that I'm going to have to deal with.
It depends on what the child therapist, Meryl Graham, says. I'm going to defer to her, not in regard to parenting time, but to the progress of the boys in processing this. So I have not seen a case where there's been a no contact for an extended amount of time between a parent and child. So I am not going to say to what extent I'll oppose it. I'd like to hear from the child therapist.
To oppose, you may not oppose lifting of the suspension of his parenting time?
I don't know yet. I want to talk to the child therapist and get her input on the process, how the boys are processing this.
Well, quite frankly, I can't override the bond condition anyhow.
I was going to say, I don't think we can. I think we're stuck in a holding pattern right now, frankly. But I'm hoping that it's my hope that the boys process this and move forward. So I don't have an answer for that yet. I really don't.
So you think we should come back in 2 weeks? It seems like a complete waste to me.
No, I think we should have the December 4th hearing, but I would like to set this for a status conference in regard to all of this if we can. I think there's a lot here. We've got two very separate issues regarding counselors and also regarding custody. So.
All right, let me be straightforward here. I can't give Mr. Feldkamp time with a kid that he has a bond condition that says he can't get time.
I absolutely agree with that.
Hold on. This is my turn right now. Okay. So unless that is lifted, I'm not going to change the ex parte. Mr. Haskell?
Well, part of the ex parte, Your Honor, deals with my motion to enforce the mediation agreement. And that's essentially that we would like the reunification therapy to continue throughout this process regardless of whether or not there's a no contact order. They do not have to be at the same session. For everything to stall and stop as we wait here, it makes no sense. These kids need to continue with reunification therapy. Mediation agreement says that Amy Van Gunst is a reunification therapist, and they're going to need reunification therapy because it's not likely that there's going to be no contact between this parent and these children forever.
I understand it's probably not going to be forever, but I don't know what's going to happen with the criminal case. And if the criminal case results in a conviction, most times from my years of experience, would probably also continue a no contact with the victim for a period of time, even if it was probation, even if he doesn't go to jail or anything. Miss Quist, what is your thought on any type of, I find it real odd that there's reunification therapy when the counselor cannot even talk to them in the same room or same area.
Well, there's two children, Your Honor. It's not.
It's my turn, please. Thank you.
Yes.
Your Honor, the reunification therapy cannot continue when there is a no contact order and a suspension of parenting time. The previous order has been superseded by two current orders. One is a bond condition and the other is a no contact order. Very serious, as you know, concerns about the reunification therapist, but it's not appropriate at this time. What is appropriate is that these boys return to Dr. Merrill Graham, who is their court-ordered child therapist. I think that is more important at this time. There's nothing to reunify yet. And honestly, these kids have never been estranged or alienated, frankly. When their dad doesn't do things, they come back. Right now it's
the reunification therapy used to include all the two boys and the dad in the therapy?
Yes.
So they were all in together?
They were, as well as my client. And it can't occur right now, and I have very serious concerns, which we are filing a motion to remove Ms. Van Gunst as the reunification therapist. It is one of the hardest things I've ever done. I'm a long-term supporter of Fountain Health. But that is happening.
I'm not going to hear that. I don't care about any of that right now. All I find is that it doesn't appear to be appropriate to continue reunification therapy as long as there's a no contact with the father and at least one of the kids, if not both.
Just one.
We will deal with the reunification and all that kind of stuff once the father's case is handled, if you will. If the bond condition comes off, I may relook at that and say that it might start up again. But as long as the bond condition's there and there's a no contact through and the suspension of parenting time through Judge Hillary, I'm going to not order any reunification therapy to continue, although that's not on a permanent basis, just until we reach some kind of a finding on what's going on here. So I'm going to respectfully deny your motion for the reunification therapy. I'm going to set an evidentiary hearing. I'm going to set something where the two attorneys and I can sit down and figure out what we're going to do on this as far as trying to streamline these hearings. Probably not real far in the future because you need to know so that you can file appropriate briefs and all that kind of stuff, witness lists and all that stuff. So look for my clerk to call you sometime to set up a status conference. Anything else either party wants at this point?
Yes, Your Honor. In the interim, child support is appropriate. The parties did not go through front of the court before because they shared expenses. There
was a zero child support before, right? A USCO zero. Mr. Haskell, obviously it's he gets no time right now, and child support is appropriate for everybody to look at. What are we going to do?
Well, I think they just file the form to opt into the FOC. They don't need a motion to do that. They can just file the form.
Right.
And
we need to set child support. Does your client have a regular pay, stub type of job? Does he get paid?
Yes, he does. Yes, he does.
And yours, Ms. Quist?
Yes, Your Honor.
Why can't the two of you exchange the financial information year to date or something like that? Run it through the guidelines, set an appropriate one.
We can.
Give you 7 days to exchange financial. At the end of that, if you both of you would run it on the same guidelines, I can't imagine it wouldn't be the same. But assuming that you have some type of a disagreement, contact my office. I'll get you in immediately to figure out what's appropriate. I don't need to have the friend of the court involved, but you do need to opt into the friend of the court if you're going to do this.
And when should child support begin, Your Honor?
Well, it actually starts at the time when it's requested, which I don't know when that was, Ms. Quist.
Now.
Filing. At the filing of our motion.
Yeah, it's the time the motion is filed, so probably be like the 1st of October was what it would probably be, just to make it clean. You wouldn't disagree with that, I assume, Ms. Quist?
I don't disagree with that, so long as the parties understand that the previous expenses in September should be status quo, which is divided per the previous order.
That's fine.
Those have already been paid, Your Honor. So.
All right. We'll start it on October 1st. Exchange. You got 7 days to exchange financial information. Run the guidelines. If you cannot come up with an amount, I'll look at both of them. Give me a call and I'll set something up. Even if I have to set it up at 8 o'clock in the morning, we'll get together and we'll get it worked out and we'll get it going.
Thank you.
Really doesn't by Zoom. All right. Anything else? Yes. This is several motions filed primarily by mother. The plaintiff first. I don't know what I'm supposed to do with an objection to the proposed order. I don't think that was even set for a hearing or anything, but.
That's for the 11th. That shouldn't be in this file.
Well, it should be in this file. This is everything was in this file.
The lady at the office, when I turned the order of the other things for 11th, she said something about the lady upstairs didn't file it right, but she'll take care of it. The one where you go file it and you pay the money to get it sent to you guys. I don't know. I don't have the best luck down there.
Well,
that stamped it.
Bottom line is, if it comes to me, I'm going to deny your objection to the order. You either got to file for a rehearing or for a de novo review. Neither of this is done through here.
So do I just go back down there then and do that all over again?
We went through all this last time. I can't tell you everything to do. All right. The best thing you could do is get an attorney, because you're all over the place in this stuff. Okay. And most of it doesn't even, you needed to file probably a request for a rehearing or a de novo review.
Okay.
And so some objection to the order. It's my order. I ordered it. So I'm not going to do anything until something comes properly before me. Number two, Mom said something about schooling. There's an order. You have a schooling motion. Have asked him the plan and when. The only thing that I said before, ma'am, was the child had to be returned to school. In your judgment of divorce, it said the kids would be at Thornapple. In your judgment, it said that. And there's been no attempt to modify the judgment or anything. We're having an evidentiary hearing here on the 10th, a Lombardo hearing, because you're asking to have the kids' school changed. And it has to be, it's your burden to prove that it's in their best interest, that it is to be moved. Not because you moved in with your boyfriend or because you wanted to move down there. It's going to have to be in their best interest that you took them out of there. You violated your own court order that your attorney drafted and said that the kids would go to Thornapple Valley.
Yes, that was when our divorce was supposed to be done though the 1st of January. A lot of things changed before that. He got a deed when we made that agreement.
Ma'am,
a lot of this whole thing.
You signed it. Everybody signed it. Okay. I'm not going to go through all this. Gee, we should have done this and done that and everything. Okay. If you want to come in, we're going to have a Lombardo hearing and you got the burden of proof. Okay. And it's not going to be easy. All right. And you're going to come in and I have a feeling you're going to come in and not know what you're doing, but maybe you will. So the kids are to be enrolled at Thornapple Kellogg until something changes.
Well, it was one kid. He agreed to the youngest one going to Edwardsburg. He did say that's fine. He okayed that one.
Mr. Bauma?
Yep.
All right. And that
and just real quick, is based on her age. Like she's 5th grade. She got
that's fine. You can agree. The two of you should agree on some of this stuff. I mean, I'm having you in here time after time, and your judgment of divorce, the ink's barely dry on it. And we're also going to look at this money that you owe, because from everything that I've seen, you owe money, ma'am.
Who, me?
Yeah.
Oh, it's broke down. I'll be ready on the 10th for that one.
All right.
The 11th.
Yeah, we'll see you. I'll see you on the 10th. And then you're asking something to do with parenting time. And,
yes.
And you stated in there, ma'am, that there's an order that you're to meet halfway for school transport.
Yeah, we're supposed to be meeting and agreeing together, yes, on school transport.
You saying that, you're telling me there's a court order for it, and there is no court order for it.
Wait, for court order, there was no court order for us meeting. You told us to figure it out on our own, how we're going to make arrangements for us to get her there and back.
The order said the girl will go to Thornapple Kellogg.
Yes.
End of story. Okay. Now you're the one who moved away, so it probably is going to become up to you to see to it if you can work something out. But I did not make an order that he was supposed to meet you halfway.
Thank you.
So I was supposed to do it all? I moved within mileage of my rights in Michigan. I just didn't do the schooling properly. So yes, I'm getting held accountable for moving.
You moved within the rights. Okay. Mm-hmm. Nobody can complain. It's just you can't move your kid. You can't take the kid out of school.
I can move the kid, but I can't take it out of school. I got that part. I did that wrong, and I was misinformed, and I was just trying to do it right.
If you're going to move away, there's no obligation of him to transport the child.
Thank you.
There is no order. And when you say there's an order for him to meet you halfway, that is just plain wrong.
Okay. We both in that court order too, we're supposed to reassign with Middleville, live in Middleville, both of us. He lives in Caledonia. And I did not say in that court order, I would be transferring my kids back and forth to school. I said we would reside them in Middleville. So how are they getting that? That shouldn't be on me regardless.
I don't care how your child gets back and forth. Your child has to attend Thornapple Kellogg.
Mm-hmm. Yep.
End of story. All right. And if you have the child during the week, it's obviously up to you to get him there, to get her there.
That's when we were moving to Middleville, both of us. Things changed. A lot of things have changed since that order that we signed. It was agreement that we both were responsible for it.
There is no court order that says that. Don't tell me there's a court order. Show to me where there is a court order that says he has to provide half of the parenting transportation. Show me the court order.
That court order does not say me neither. I have to do it all.
That's fine. It does not, but it falls on you if you're going to take the child 90 miles away. And if you are living here and you have during the week, it doesn't require him to do anything.
But he has say to where the kid goes to school.
The court order has...
he's not the one taking her.
The court order says the child will attend Thornapple Kellogg. And you have the child during the week. There is nothing to indicate that he is supposed to transport her.
Tuesdays and Thursdays are his visitation day.
Okay.
And on that court order, it says on his visitation, he's responsible for getting her.
As I recall.
Does he have a license now?
I don't know.
Yeah.
I'm just recalling, didn't it say you're responsible? You can have him on Tuesday and Thursday if you have a driver's license?
Yes, sir.
All right.
Once you move 90 miles away, I spent 3 hours in the car to go pick him up, an hour and a half away. And the Tuesday, his parenting time was from 5 to 8 in the evening. I'd pick him up from school or whatever and get him after school for 3 hours.
Well, if it's from 5 till 8, you'd have to drive down to her place to get him.
Right. For what? And then, I don't.
You weren't doing it though when I lived in town. You weren't seeing him, or you weren't taking him on your weekends either for 4 of those months. So I mean, it don't matter where I live. You neglected to do your parenting time, regardless of where I was located, and I have proof here.
Good luck with that.
We're going to have a hearing on this on the 10th. All right.
You say, Your Honor.
The 11th. I'm sorry.
Okay. Thank you.
Sorry. We're going to have a Lombardo hearing on that date. You're going to have to prove that the kid should be moved to wherever you want the child to be moved to, ma'am. It's your burden. You're also going to, sir, you're going to be involved in and show as to why she owes you money.
Yep.
All right.
Yes, sir.
You understand what's going on? I'm not changing any parenting time or anything right now. Because the bottom line is, ma'am, if you move down and he only gets 3 hours of parenting time, by the time he picked up the kid at 5 and drove back, he'd have to turn around and drive back to get the child back there by 8. That's all he would be, is in the car. Absolutely. So I don't know how he would. I mean, you can make a motion to eliminate the Tuesdays and Thursdays, or he can make a motion to eliminate the Tuesdays and Thursdays. There is no way that, I mean, I don't know what you would expect. He would drive down there, pick up the kids and drive back, and then turn around and drive them.
Yeah, he wasn't taking them before I moved down here, so it don't matter.
All right. So anything else we need to deal with?
But that, yes, there's a child support case, child support too.
And
he told my lawyer he was only making $21 an hour, not working 40 hours, which was a lie. He screenshot me one day a transaction. His check was 8 something in his bank account for 1 week. And that's when I found out he was making more, and he also has a second job.
Well, for the first place, I don't know what he told your attorney, and I don't know anything about mediation because I'm not involved and there's nothing from mediation. Sir, how do you respond to that?
At the time of mediation, I had one job and I was working 39 hours a week, making $21.50 an hour. My child support went into effect the first week of April. So before we even had sold our marital home, I was getting like $153 taken out of my check every week. And in that child support, I also pay like $53 for medical support, but I provide my kids with full medical insurance, and
probably be taken into account in that. I don't know. Let's see.
It is.
You DSO.
I have to pay so much money of bills before he does for current.
Yep. All right.
I think it's 4,000 something.
So, and I just got a second part-time job as a line cook because I'm a week behind on every bill because my 40-hour paycheck is $500. And
how much do you make? How much do you make an hour?
Right now, 20. I just got a raise last week, 50 cents. I make $22 an hour for 40 hours a week. Take home is $500 for 40 hours, $501.
So I don't find that to be a substantial change of circumstance to warrant a review of, since it was, geez, oh, Pete, it's only 6 months old.
Yeah.
She told me in the beginning I was going to change it because when she calculated the time difference, it was 900 and something per month of child support. She said, once this is done, I can call, appeal the child support. That was the mediator.
I don't know if that see, here's part of it. I'm not involved in the mediation at all. And I can't know what a mediator says. I'm not even supposed to be involved in it. That's something that you guys turn into a court order and you live with it. Okay. The amount that I show is it $637 a month that you owe?
I think I think it comes out to $690, but
I get $143 a week on.
I don't know about that.
Yeah, it's about 700. So
not 700, it's 560 or something like that with what I get after the rate.
March 30, 2023, there is a order that is put in for child support. It was drafted, I believe, by your attorney, ma'am.
Yes.
And it appears that it was signed on March 30 by Judge Hillary. If there's not a substantial change of circumstance or a change of circumstance to warrant something, then
he gets some. It does. His timing, his parenting has changed too. He only gets them 4 days out of the month. This was calculated for Tuesdays, Thursdays, and on his weekends, Thursday through Sunday.
Yeah, because I agreed to Thursdays take them from school and bring them to school Friday morning because I didn't work Fridays. But when you move 90 miles away, that kind of made it.
You didn't do that before, Michael, so let's not stop using excuses.
Do not argue on this. We're going to do this civilly, whether you guys can be civil or not. Okay. You can state your stuff and he can state his stuff. All I'm saying right now is how many hours you working extra on a second job?
During the week, Monday, Tuesday, Wednesday, I get out of work at my full-time job at 4:30 and then drive straight to the restaurant and work 5 to 10.
So how many overnights are you taking? You're taking every other weekend, Friday and Saturday?
Yes, sir.
And that would be, and are you getting any time during the summer and stuff like that?
That wasn't established. I referred to that back in August that I was supposed to have them 1 week on, 1 week off after I'd, gotten established in my apartment, but she insisted that it was every other weekend, and school started
every other weekend means you get 52 overnights during a year. You're being credited with 93.
Yeah, because that was for the Thursday nights.
Right, that is a change of circumstance. I'll send it to the friend of the court and I'll take a look at it.
Okay.
FOC referral for that. Anything else?
Yes. When he's had my kids, he's drinking and driving with them. I have one incident, I have texts to prove it. He responded back. He only had 2 beers driving with her. He had a DUI back in, I think, November. He crashed a rental, left the scene of the accident.
That was before you signed the judgment of divorce.
Yes, that's why we did that. That was because we got divorced. But then that's when, after this, he went drinking again. After he just had that incident, he was driving and drinking with my daughter again. This is not the first time. Back in February, this recent past, he has also did it again. And then this summer, I called him out again. I told him, you better not be drinking. He said, well, walk home then.
And then I said, we live
on his 4 days he has him with a month. He is at the bar. I have text 2 of my daughter asking him when he's coming home because he's watching my youngest daughter as he's at the bar partying. Another incident.
What am I supposed to do? I'm supposed to eliminate all his parenting time?
No. I mean, if
we will add something in. It says, sir, you're not to consume alcohol during the times that you have the children.
It's fine. I'm not. That's easy. I had 1 beer with dinner with the girls a block away from my house, but she's
no consumption of alcohol during any times that you have the children.
Okay.
All right.
There's also another situation. He took my daughter on a electric scooter ride on M37, and she crashed. Cops were called, and I was not reported to me. I got an alert in my email from the emergency room saying
what am I supposed to do with that?
I'm supposed to be notified if my kid is hurt or
notify her if you go to the hospital or if your kid's hurt. You hear me?
He shut off the phones, so I couldn't even see the status of my daughter while she was in the ER. I had to call the hospital so they could report how she was doing to me.
Can I add something?
Briefly.
Have you ever been in the basement of Helen DeVos Children's Hospital? You don't have service down there. That's all that was. I wasn't turning off my phone or turning off my daughter's phone. And she was alerted the second we pulled in and she was put into the computer system. Ashley got an alert through her Spectrum my chart saying that she was there.
I'm not going to do anything with it other than to tell you if your daughter is injured or hurt or something like that, you need to contact mom. Just like you got to contact him if your daughter's injured or hurt or something like that. We'll see you guys here on Wednesday, is it?
Yep.
In court with all your witnesses, all your evidence. You can't just email it to me. You got to send it in. I got to get hard copies of stuff.
I'll be there to drop it off today.
You understand that, ma'am?
Yeah, my printer broke. The ink is out. I got it coming today, so I can print that and send that to you. I'll have it in. I'll drop it off, actually, to the courthouse.
Good luck. We'll see you here on Wednesday. Thank you for adjournment. Hello, everybody on YouTube land, Romania, Traverse City, Kent County, whatever. We have, all right. Nobody here looks like Wayne Crow, thankfully.
Good morning.
Good morning.
No, Mr. Crow was elsewhere this morning, so I'm appearing with you, Allard.
All right. Let's see. We have Mr. Allard. Are you there?
Yeah, I'm here. Mr. Peterson asked me to apologize. He was never sent any information on this, and he said he's tried to contact Mr. Crow, and he would told me to ask for an adjournment on it since I didn't send him any information.
I have, Your Honor, in response to that, I have no information that Mr. Peterson was retained on this matter. I don't have any appearance for him, continuing an appearance post-judgment, and this was appropriately filed and served on Mr. Allard, and it was Mr. Peterson's responsibility to get a hold of us if he had appeared. Does the court have an appearance in the file?
I don't have any appearance or anything.
He was at the last motion that we had. Last time they filed, he was here representing me.
Well, that was months ago, was my understanding.
Was that about this?
Yes, that was the same case. He was at the last motion that they filed. And I don't know why they keep leaving him out and just sending it to me as I'm defending myself.
Because they have to send it to you because Mr. Peterson is not obligated to be your attorney. So if they sent it to Mr. Peterson, you could say, wait a minute, it's not mine. He's not my attorney. Where are you? Can you show video, please?
I was trying to turn it on. I don't know.
Allard v. Allard. All right, Mr. Allard is present. So is Miss Allard. Miss Allard is represented by Miss Camfield. This is a motion to enforce basically a qualified domestic relations order that's been out there to be entered for I don't know how long. Looks like, let's see. There was quadros were sent in March to you, sir?
Yes, that's correct. And they were supposed to. We had our last motion, and Mr. Pete, they have the loans as all my responsibility for the 401k. Mr. Peterson did say that the my pension one is correct. We can get that signed, but he told me to ask that ask the language of state that she gets 50% of the value less 50% of the loan balance on my 401k.
And Mr. Frederick, respectfully, I'm going to disagree with Mr. Allard. The judgment of divorce that was signed and entered last year by both parties indicated that any loans or debt in any individual's name was going to be the sole responsibility of each individual. And furthermore, there's not been a motion to correct the judgment. There's not been a motion to set that particular provision aside. There simply was no responsibility of Miss Allard for that 401k loan pursuant to the judgment. They all signed and entered.
Well, I guess what I'm having real problems with is even if he claims that there is something that should have been done, I am now 6-7 months past when the original stuff was sent, and there is nothing in my file to show that, oh, wait a minute, you guys got this wrong, and we got this and we got that.
Correct.
Mr. Peterson said he's been in contact and they will not get back with him, Your Honor. I have messages. I was talking to him this morning. He was going to be here, but he is in Grand Haven in court this morning, so he couldn't be here. That's why he asked for an adjournment, so he could be here to represent me.
Well, I guess the concern that I have again is that attorneys are released by the judgment from further representation until retained and they file a new appearance.
All right, now,
I haven't received one.
I do find that Mr. Peterson apparently was here at the June motion.
Correct.
Okay, and this dealt with the same issues as I believe.
That is correct.
I'm gonna grant a 2-week adjournment, and I'm going to be real specific about this. All right. Mr. Peterson had better submit his objections, and they better be valid objections, or I'm going to award attorney's fees for messing around with this thing forever. Okay. You say one of them could have been that you have no problem with signing it and sending it. I don't know why that wasn't done then. It better be done before 2 weeks from now.
Well,
I'm just telling you, okay, this is not your turn, okay? If you say there's no objection to one of them or something like that, then I don't know why it wasn't sent, right?
I've never got anything to sign, Judge. I'm sorry. I just got this thing that we had a motion to come back to court.
Okay. They've got plenty of stuff in here to show how they've sent stuff to you and or Mr. Peterson. I don't care who, okay? Yeah, you can't just keep sitting on this stuff. And it should have been done months and months and months ago. And I'm going to find that you're sitting on it. All right. You better get it taken care of. We'll put this on for 2 weeks from now to adjourn it to then. I'm going to reserve attorney's fees because I'm getting very angry about the fact that this is not being taken care of. All right.
I apologize, Your Honor. I'm not trying to hold it. I'm just
telling you how I feel. Okay. I feel because it was originally sent out in March, and that was 7 months ago, and nothing has been done about it. All right. And in 7 months, it should have been taken care of. And even if Mr. Peterson has called and hasn't had a return call, he should have sent emails. He should have sent a proposal. He should have done something. We got to get this done. Mm-hmm. And you better tell Mr. Peterson that it's got to get done. Don't bother telling me excuses or anything. you got 2 weeks to figure this out. If I come back in 2 weeks and I'm still dinking around with this stuff, you're gonna end up paying her attorney's fees and your attorney's fees. So we'll adjourn it for 2 weeks.
Thank you, Your Honor. Would you like us to renotice it for October 20th at 8:30, or would the court do so?
Could you please,
Yes.
just so that we're sure, send the notice to Mr. Peterson too? All right.
Yes, I will.
Because,
thank you.
And I mean, I think real highly of Mr. Peterson. So let's see what we can come up with. But there's no excuse for this having 7 months and it not being taken care of.
I will go ahead and reach out to Mr. Peterson for clarification.
Thank you. We're adjourned.
Thank you.
Is this the last one? Yeah. Just lies. Doesn't even care. Just lie. Yes. Gibson versus Robinson. Both parties are present via Zoom. This is father's motion for parenting time. There is no specific parenting time in the orders in this case. However, the father has asked for every other weekend and to see the child also on Thursday night. Ma'am, do you agree with that?
No, I don't.
All right. Then, sir, what's your, I mean, you've asked for this. What do you want to say?
I just want the time with my daughter. Actually, I've been blocked from her phone. I'm not able to contact her in any way. I believe it's over money.
When was the last time you saw your daughter?
Actually, the only way I can see her right now, I went to her school and had lunch with her last week.
All right.
Outside of that, it's been very inconsistent.
Ms. Gibson, why can't he see his daughter?
He can. It's just that I don't agree with the time that he wants.
Well, what do you think he should have?
What I don't agree with what he has put in this motion for parenting time. It's not, in the past, I have offered him every other weekend, but it was never consistent. Like, he's never been consistent enough in her life to stand on that.
Well, but it'll be a court order now. So what do you think he should have?
He can do, I mean, if he can do the every other weekend, but I don't agree with the overnights because she has expressed to me that she's uncomfortable with it.
Where does it, sir?
Yes.
It doesn't help if you're laughing and stuff like that.
Oh, I'm sorry.
Treat this like it's important. All right.
Oh yeah.
All right. Why do you have a home that you live in?
Yes.
Who do you live with?
Me and my girlfriend live together.
Do you have other kids?
Yes. Yeah, I have a daughter, and my girlfriend has a daughter.
All right. Does your child have room to, a place to stay when she comes visit you overnight?
Yes, she has her own bed. Her and my girlfriend and daughter actually share the bedroom over here.
All right.
And it's been like that since I've been here.
Have you ever had overnights with your daughter?
Yes. We did every other weekend and one night a week for about 2 months, and then all of a sudden it stops. I'll ask if she's coming over this weekend, all of a sudden it just stops.
All right. So what's wrong with him having every other weekend?
I'm okay with him having her every other weekend during the day, but because she has expressed being uncomfortable with overnight, that's what I'm not okay with.
Well, why is she unwilling to spend overnight?
Recently when I just talked to her.
I'm asking mom right now.
Oh, I thought you said sir. I'm sorry.
No.
She told me that because I asked her about where she's sleeping when I FaceTime her, and she's always laying on the couch. So she told me that there's always things on her bed. One time there was a TV on her bed, and I told her to express that, and she seems like she is uncomfortable with expressing concerns that she has.
Well, you've just expressed it here right now, Mr. Robinson. You got to make sure she's got a bed that's open and safe and all that kind of stuff for her. Do you understand?
Yes. Whenever she's here and they sleep in the living room, it's by choice. We'll tell them, you guys can sleep in your room. We'll even try to make that the rule, and they choose to sleep in the living room.
I understand that the kids, I understand 10-year-old kids like the out and stuff like that too. It's not, especially when you don't get much time with them. So Well, what we're going to do is, ma'am, do you want to start this weekend or next weekend? And I'm going to make the first weekend, he's going to see her Saturday, overnight to Sunday. And then the next weekend, it's going to be Friday to Sunday. Do you want to start this weekend or next weekend?
Next weekend.
All right. So starting next weekend, sir, you get her at 10 o'clock in the morning on Saturday. Okay.
Okay.
Through 5 o'clock on Sunday.
Okay.
Okay. And make sure that she is comfortable there and all that kind of stuff. All right.
Okay.
From then on, it will be Fridays at 5 o'clock till Sunday at 5 o'clock every other week.
Okay.
All right.
Okay.
One time to go there so she feels a little bit more comfortable.
Okay.
And then one evening a week you can see her, but not overnight.
Okay. And I'm okay. I work nights, so I'm okay with that.
I mean, ma'am, how about he picks her up from school on Wednesday and has her to you by 7 o'clock on Wednesdays?
So every day throughout the week, she goes to dance practice from 4:30 until 8 p.m.
Every day?
Yes, she's a competitive dancer. And so she dances at a studio here in Grand Rapids. And this year, her schedule is more extensive because she has a solo and a duo, and she's in 4 routines. So she is at the studio every day.
When does that, I mean, so she goes from after school till?
I pick her up from school, and then she goes until 8 p.m.
When does she get to do her homework and stuff?
She does it on her breaks at the studio. They have a homework room.
Sir, do you know where she goes to her studio and stuff?
Yes, I'm actually took her to a tournament in South Carolina this year. So yeah, I'm aware of the
here's what
dance
the problem be. I mean, I'm not gonna have her stay with you as opposed to going to her dance class.
Oh no, I can be her transportation to her dance class. That was actually part of our thing when she was coming every other weekend and a night out the week. I was taking her to dance. So that was never an issue.
That was part of an issue. There were a few times that he did not take her. I would track her location on her cell phone, and I texted him a few times and asked why she was not there. And he told me, she said she didn't want to go. And so when I asked her, she said that her dad said he wasn't taking her.
I would have to see some type of that has never happened.
No, you don't have to see it. I would have to see it.
Yeah. I've never not because I've only.
Ma'am, how long is she going to be in this? I mean, when is her? I mean, does she go year round or what?
Dance is a year round activity. They do have breaks, but it is year round. But her schedule this year is only extensive because of the amount of routine she chose to be in. She last year, she only went 3 days a week, but this year, because she's in specialties like her solo and her duo, she is there more.
All right. So how about if we say if she isn't, when does she perform so that we go to the next?
So her performances start in late winter, early spring, and they're over weekends. We travel to them.
From now until late winter, early spring, she is going to be 4 days a week in competitive?
Yes.
Or does she get some breaks?
They do get breaks. Like, they don't go over Christmas break. They take a week off for Thanksgiving. They they try to fit with the school schedules where they get breaks.
All right. How about if I say that on Wednesdays he must take her to competitive?
That's fine.
Must take her there. He can pick her up after school, sir. All right.
Yes.
And you have to get her to dance on time. Okay.
Okay.
And are you able to take her back home afterwards at 8:30?
I'll go to work at 6:30, but I can't get her back home.
You go to work at 6:30 in the evening?
Yes.
Oh, then just take her there. And ma'am, do you mind going to pick her up?
No, I don't.
All right. You can take her to dance on Wednesdays stay with her, watch her, do whatever you want. And if she does not have dance, then you can have from Wednesdays from after school until 8 o'clock.
Okay.
All right. Does that work?
Yeah, that works.
All right. So then after school until 8 o'clock. All right. But if she, and I'm going to stress this to you, if you don't take her to dance, you're going to lose at least Wednesday nights. Okay.
Okay. Yeah, I understand that.
This is something I don't want her to suffer at all by doing anything. You can stay and watch her. It'll be a nice time, even if you only get 15 minutes with her in the car.
Oh, yeah.
It's something to do. Okay.
Oh, yeah. Yeah. Like, yeah. Because this is, I really can't recall any time that I didn't take her when she was supposed to go. I don't
care about that now. This starts today. Okay.
Yeah.
Ma'am, and if he doesn't take her, you can come back in front of me and I'll take the Wednesdays away from him and who knows what else. Okay.
Okay.
All right. Yeah, I want him to have a good relationship with his child. And part of that will be based on if you do take her to some of these things. And I hope you'll be able to go to some of her competitions when she has them in, I don't know when it is, March or something like that. Ma'am, he should be allowed to go to those competitions and stuff too. And if it falls on his weekend, okay, then he must get her to those competitions or send her to you and you can take her there. Okay.
Yeah, he can't be in the dressing room with her to help her.
Absolutely.
So that, yeah, so I'll always be there no matter what.
Okay.
So
well, that's fine. But I'm just saying, assuming it's a competition on March 23rd weekend, okay?
Yeah.
And it's his weekend. Because he'll have her Friday night, he can have her get her there Saturday or contact you and say, I can't get her there because you'll go anyhow, okay? Sir,
yeah, I just took her to South Carolina in June for a week-long competition and she wasn't there. There were always moms that are there to help. So I am
that's
able
great,
to take
but I'm not gonna get either of you. I'm not going to have either of you not go to those competitions.
Oh, yeah, I understand.
That's really great time. Even if it's your weekend or not, you can go to the competitions, even if it's mom's weekend. Okay.
Yeah, and I plan on it. Yeah.
You know, that's just the way things go. All right. All right. The next Saturday, 10 o'clock till Sunday at 5. And then every other weekend after that, from Friday at 5 to Sunday at 5. Wednesdays after school, but you have to get her to dance unless there is no dance. At which case you'll have after school till 8 o'clock.
Okay.
Good luck. You guys start working together, please.
And I'm sorry.
Go ahead.
I have no way to talk to her throughout the week either at this time because I'm blocked from contacting her.
Does she have a cell phone or any way to get in touch with her, ma'am?
Yes, but
she does have a cell phone.
Does he have the number?
Yes, he does.
Sir, can you call her?
Yeah. Yeah, I'm blocked from her phone. My phone number is blocked from Kari's phone.
Unblock her, ma'am. But you guys got to start. You're going to be this child's mother and father forever, okay? And I want her to have a good relationship with mother and father, okay? And let's start working towards that goal, all right? You guys need to get along enough to co-parent, even if you don't like each other or whatever. You need to get along enough. If he drove down to South Carolina to be with her at a dance competition, that shows that he is committed to her. Maybe not the way you think, ma'am, but you guys got to start working this stuff out. Unblock his number from her. Don't abuse it. Don't call her every 10 minutes.
No.
Just every now and then, okay?
No, yeah.
All right. Good luck, everyone. Start getting along better, okay?
Okay. Thank you.
Both parties are present via Zoom, as well as Mr. Carpenter, who is representing Mr. Duchesne. This is the plaintiff's motion for custody. The only thing I could really find, I think, because this is a paternity case, is a UCSO that showed that each party apparently had 50-50. I can't find a custody parenting time order in the file. Ma'am, what is the current agreement or what's happening with custody?
The current agreement that we're doing is pretty much Sunday through Wednesday, 1 week, and then it switches. So then it'll be Saturday through Wednesday.
Are you guys basically splitting custody?
Yes, we have split custody right now.
All right, Mr. Carpenter, what would you like to say about the motion?
Thank you, Your Honor. The parties have 50-50 joint physical and legal custody. I don't know why you're having difficulty finding that order. There might be a problem with the record, but I'm sure we've got a copy of the written order here that we can address that. But essentially, the parties, the mother enrolled the child unilaterally in some kind of preschool program, didn't tell my client until she had done it, and now she's trying to use this as a basis to request primary physical custody. I will concede that given the fact that my client lives in Muskegon and Miss Logwood lives in Grand Rapids, I think that there's inevitably going to have to be some sort of reckoning because this child is going to have to attend school, and neither of these live too far apart in order to maintain the current custody and parenting time schedule. But I don't believe that the mother has set forth any basis for requesting a change in custody at this point. She wants to put the child in preschool, or so she says. But the school district she lives in has an abysmal public school. Checking the statistics, only 15% of the enrolled students are achieving proficiency in the tested subjects. My client lives in a suburban Mesquite school district with a much better school, and I do believe that ultimately we're going to have a hearing on where this child's going to go to school, but I don't believe that there's any, Vodvarka hasn't been met here, and I believe that this motion regarding custody should be denied.
Right, because she wants Monday through Thursday, and then Dad to have every Friday, Saturday, Sunday.
Yes, I understand that, and but she hasn't framed this as a motion regarding school enrollment. She hasn't provided any of the data. She's called it a motion to change custody, and I think we have to treat it as just that. She's using the school enrollment, I think, as a basis or an argument, but we're dealing with a child that's so young at this point. School enrollment's not even mandatory. So while I do agree that we're going to have to address parenting time, and it's going to have to be modified to facilitate attendance in one school district or the other, the argument's going to have to be, what's in the child's best interest regarding one school district versus the other?
I understand that there's going to be, ma'am, because you have joint legal custody, if you cannot agree on a school that the child will go to, we have to have what's called a Lombardo hearing, and for some unknown reason, I'm going to have to pick which school the child attends if the two of you can't agree. And it sounds like you're going to ultimately have some problems with that unless you start agreeing to it. Now, this is not mandatory school, is it? This isn't even kindergarten. This is a preschool, right?
Correct, yes.
When does the child attend preschool, or at least the proposed?
He was supposed to start September 7th.
But he hasn't started yet?
No.
And what are his days supposed to be?
Monday through Thursday.
Well, at this point, I don't believe Vodvarka has been met. And that's probably, Mr. Carpenter knows what Vodvarka is. You probably don't. That has to show a change of circumstance or proper cause to have an evidentiary hearing. I couldn't change any custody here today, even if I wanted to. Okay. We'd still have to have a hearing, and I'm having hearings out as far as February right now to even do this. So I couldn't get it to change right now as it is. What I'm urging mother, father, and Mr. Carpenter is to start figuring out it'd be nice if the child could attend some kind of preschool. I don't think anybody would agree that it's not in his best interest to attend some preschool. And maybe you can figure out something where the child can attend some kind of preschool. Okay. And then the bigger question is going to be probably next year when the child attends kindergarten, where's he going to go to kindergarten? And that, if the two of you can't agree, I'm going to tell Mr. Carpenter and you, ma'am, but you better get it on in front of me sooner rather than later. Don't wait to make a motion in July, a school motion, because I won't get it on in time for you to get to know when the kid, what school district kid goes to. So I'm going to deny your motion for change of custody right now because it doesn't meet proper cause or change of circumstance. However, I'm really urging the two of you, together with Mr. Carpenter, who knows what I'm talking about and can maybe even facilitate some of this, that everybody's got to start figuring out where is this child going to attend. Maybe you can even get the child to attend some type of preschool here now through some cooperation, different ways or whatnot, to do this. Maybe he attends Monday, Tuesday, Wednesday through mom, and maybe you can get the child there on Thursday or Friday. I have no idea, okay? But we got to work for the best interest of this child, and the best interest of the child is to attend preschool and then attend school, okay? So I'm going to deny your motion right now, ma'am, and with the understanding that I'll probably be seeing you sometime on a school issue, but you can't start working on this soon enough because I assume, will the child start kindergarten next year?
Yes.
All right, then, Mr. Carpenter, I assume you will talk to your client appropriately so that we can start getting to this issue. If it needs to be a joint legal decision and nobody's going to be able to agree on it, then I guess you should contact my office for a Lombardo hearing.
Thank you, Your Honor. We'll do that.
Something like that, you know. All right. The two of you have got to work on this, and this is going to be a problem because you don't live very close to each other. Okay. But you got to work on it with your child's best interest foremost in front of your mind, not your interests. You both agree to that?
Yes, sir.
Yes. Yes, sir.
All right. Let's hope that you can work it out and figure this thing out. Other than that, I'm going to deny your motion for change of custody today, and we'll deal with something in the future. Good luck. Thank you, everyone. Mr. Arnson, who is representing the defendant, Mr. Oakes. There are 3 children involved in this matter. This is mother's motion regarding parenting time, having to do that. In the past, I understand all the kids were being homeschooled. Now they've determined that the parties agreed that they would go to Cedar Springs schools, at least the 2 oldest. The youngest is still being homeschooled. But they then didn't choose the district that they live in. They chose Cedar Springs as a school of choice. Now there's issues of getting the kids to the school. Ma'am, what do you got to say?
We have a verbal agreement that Mr. Oakes was going to be picking up the kids from my house, even though it was my weeks, and getting them to the bus stop. And as of 2 weeks ago, he has refused to do that, stating that I now have to take care of all transportation on my parenting time. One of the reasons our children were able to go to Cedar Springs was because we had this agreement. I run a daycare. I open at 7 a.m. I provide breakfast for the kids. So I do not have.
What time do the kids have to get to the bus?
The bus picks them up at 6:28.
Why can't you take them there?
It's 13 minutes from my house. So by the time I take them, wait for the bus, get back home, I have 10 minutes to get breakfast and open for my daycare kids. So the agreement was he would handle the before school, I would handle the after school. Had that not been the agreement, Elena would have been continued to homeschool, and our son Logan, homeschooling was not working for him, would have been enrolled into Greenville and would have taken the bus.
I also note there's a request for a neutral location for your exchanges on Sundays, which Mr. Arnson and Mr. Oakes agreed to. Is that correct, Mr. Arnson?
That is correct, Your Honor.
And I think that was, what is that, Farm and Tractor or something?
Tractor Supply Company.
That's okay with both of you?
That is okay. I do have a request.
Just asking Mr. Arnson.
Oh, I'm sorry.
That agree?
That is okay with my client. It's about halfway between the parties. It's a it's a neutral location.
That's fine. All right. All right. So, Mr. Arnson, what have you got to say about the transportation on her time and whatnot?
Your Honor, I think we tried to make it a little bit clear in our response here. There certainly was a dust up. The police were called on the 20th of September. Mr. Oakes did obtain the report. The police aren't going to press any charges against either party here. Right now, I think it is, my client believes it's best that the children, the pickups and drop-offs occur at a neutral site. Really, these folks really need kind of a break from each other.
I've had them in front of me too often lately, to the point where I'm beginning to think I should take their kids and raise them, because they can't get along well enough to raise the kids together.
Your Honor, I think, and certainly I looked at the court docket and I talked to my client about the frequency in which the parties have been before this court. I think what we need to probably do is make sure that these parties do not see each other as best as possible. So these pickup and drop off should occur at a neutral location. Also, it seems to me the easy solution is that each party is responsible for getting the kids to and from the bus stop on their parenting time.
But did he, Mr. Arns, I agree with you, except to say, was there an agreement early on that he would get him there? And he did get him there, and now everything's changing, okay? Which I understand is not a court order that he'd take him there and stuff like that. But my real concern is we're a month or two into the school year, and he was doing it, and then all of a sudden it changes. She does run a daycare that I understand, and there's a question of how long it takes her to get her there and that. And I am going to say that obviously when the weather gets worse or something, and if she is there at 6:30 and the bus doesn't show up till 10 minutes late, she won't make it home in time for the daycare and this kind of stuff. Let's work on more of a practical solution than anything else.
Well, the agreement, Your Honor, and my client does agree that there was an agreement. It was his understanding, the agreement, that Ms. Behrens was responsible for getting the kids to him after the school day on his time.
Yeah.
That hasn't happened. So he has to either pick up the kids after school, they end up going to her house, or she has people transport them, they go to friends' houses. So Mr. Oakes is not only doing a lot of traveling in the morning, which he agreed to, but he's also doing a lot of traveling at the end of the day, and that wasn't what he had agreed to.
Why is he traveling at the end of the day? Why aren't the kids showing up at his house, ma'am?
The kids were dropped off at my house, and Mr. Oakes was picking the kids up from my house at the same time that he picks up Judah, because Judah is at my house for homeschooling and he gets picked up at 6 o'clock. The only reason that he is now traveling more is because our son Logan, as you are aware with us being in front of you before, we've had issues with him. I've given him permission to live with his dad right now because he refuses to listen to me. So Mr. Oakes has set it up that Logan is able to go to his best friend's house and stay there until Mr. Oakes is able to pick up Logan at the end of the day. Logan does not want to be dropped off at my house. Mr. Oakes has not done any additional driving other than coming to the same location to pick up all three children since school started.
Is Mr. Aronson, is he going on the weeks that he has the kids? Okay. Is he going to her house to pick them up?
That is my understanding, yes. He is. So after this agreement was entered, it became clear that the kids weren't going to be dropped off at his house during his time. So now he is dropping them off and getting to the bus stop every morning, and also picking them up at the end of the day during his time.
So why don't you see to it that the kids get to his house at the end of the day, ma'am?
Because again, I run a daycare. I don't have enough room in my car to transport. So before we enrolled the school, I made sure that I had transportation from the school to my home, which was court ordered that he is to.
Okay. When
that
is,
the kids
when
are
is
at my
your
house.
daycare in?
5:30.
Well, so what time does he come to pick up Judah and stuff like that?
6 o'clock.
Why can't you take him over there?
I have no problem doing that. However, after the most recent altercation, I do not feel comfortable going to his house. It's a secluded parking lot where he trapped me in, so I'm willing to meet at a different location. However, there are times that daycare parents are not here on time, so he will need to be flexible. And also, his schedule is never consistent. So I don't ever know when I can meet him, and he knows that. His schedule changes from day to day. And yesterday I met with him in a public location. He agreed to go back to the court order on Thursday and Friday. I agreed to meet him at a neutral location, and it puts us at more opportunity for altercations. Mr. Oakes proceeded to pretend to throw a soccer ball at my vehicle, slam his body into my car, put his elbows up on the windowsill, and then put the ball inside my car. If the goal is to create less interaction, him picking up the kids from the front of my house and the kids going outside and me never having to see him is the best solution.
Well, it can be that you drop him off at his house and you don't have to see him and he doesn't have anything to do with you.
But if he's not home, I can't drop an 8-year-old off at a home by themselves. Elena has had volleyball. She is still in volleyball every day after school until 5:30. Mr. Oakes has not picked her up from volleyball practice this week, has not picked her up from volleyball games. So I can't drop off a minor child.
You're the one saying that he shouldn't be allowed to see his daughter right now anyhow.
I'm not saying he shouldn't be allowed to see his daughter. I'm asking that they go through some kind of counseling, therapy, reunification counseling so that they can repair their relationship, because I want them to have a good relationship.
You're not going to change custody order or parenting time that he gets with your daughter right now. I will order that the parties find and agree on a counselor for Elena. That's fine. But
she has a counselor right now.
Fine. Then does he know all about it?
Yes.
Sure. You know the names and everything, Mr. Arnson?
My client does. In our response, we think that there's clearly some stuff going on here. I'm sure that the plaintiff will point the finger at the defendant points the finger at the plaintiff.
I understand.
The fact that the oldest child is not allowed and is struggling with a relationship with his mother. Now the mother's saying that the middle daughter is having a struggle with her relationship. We really think that the counselor should have at least some sort of background in either resist-refuse dynamics or divorce issues between parents. A general counselor, I don't think, is going to assist the issue. So,
has your client talked to the counselor to even know?
I think he's had some conversations. He knows who the counselor is.
Well, I'm saying I don't want to necessarily change her unless it's really necessary to do that. If your client has some real conversations with the counselor and says, wait a minute, this just isn't appropriate for it, then that's one thing. But I would like him to see if we can deal with that counselor first. Okay? I mean, Mr. Oakes, have you spent time talking to the counselor and try to figure stuff out with her?
I attempted. They would not take a phone call from me. They said they don't do that. They need everything to be via written record. So it was only via email. I have been told on a couple occasions that, they were thinking that it'd be good for me to be in counseling with Elena. I agreed immediately upon that. I think probably the first time was over a year ago, and no one has ever reached out to me. They say Elena's not ready.
And if they don't, how about you reaching out to them? And if they don't accept you in there, then we're going to find her a different counselor.
Well, I've attempted that, and that's the thing is then I'm being told, well, Elena's not ready to do so. So I feel like a different counselor would be beneficial because clearly this one's not progressing Elena's feelings of wanting to seek counseling with her dad, who she doesn't want to talk to at the moment.
Do you know that this is virtually an impossible thing to figure out? Because if I send to another counselor and Elena decides I'm not going to talk to that counselor, then what do? I tie her down and say, talk. All of this stuff is just ridiculous for parents to be going through between the two of you. I mean, I'm blaming both of you. Sir, you need to get in contact with that counselor and tell the counselor that you are to be involved. We'll issue an order that you are to be involved with Elena's counseling. All right.
Okay.
And if they don't like it, then they can get rid of her as a someone. But you are to be involved with the counseling also.
Understood.
She's currently on a hold right now with her counselor because she got to an as-needed basis. So if Mr. Oakes would like to contact the counselor and schedule a joint session, I will let him handle that.
Well, yeah, and you're telling me that Elena's receiving counseling, but then you say it's on hold and not as needed. Maybe I should allow Mr. Oakes to pick a counselor that she has to go to. I mean, why can't we figure out a counselor that dad goes to with the child?
He is more than welcome to find a counselor. He was actually initially supposed to find the counselor for both Elena and Logan, and he didn't.
Mr. Arnson, you can draft the order that your client can provide a counselor and that she will be responsible to attend that counseling.
Very good.
All right. But you need to find one soon. All right. Very soon.
Understood, Your Honor.
What else do I need to deal with here? I need to figure out what we're going to do about the transportation. You agreed to do it, sir, so I'm going to kind of hold you to it. But I want, on the times that the kids have to come back to you, ma'am, you're going to be responsible to drop them off back to him. There's no order that prevents you from doing it. There's no PPO or no contact and things like that. Two of you got to think and grow up. And Mr. Oakes, if you're doing stuff that is even making her feel uncomfortable, cut it out. Come on. I mean, geez, oh, Pete, do I have to come and show up and see if you guys are acting like you're adults? I mean, what on earth can't you get along? You got kids that are going to be your kids forever. Forever. And you aren't going to be able to get along when you go to the graduations because, you know, you're going to want to poke fun at her or do something with her. Or she's going to be a pain in the neck to you. I mean, what is it? Can either of you tell me what the problem is? That you cannot figure out to act like an adult when you're around each other? I mean, there's such a deep-seated hatred that you can't get over it?
I don't know why we can't. I thought we were getting along just fine. We have been able to communicate for the last several months. We came up with the agreement about school, and we had the issue 2 weeks ago, and everything has gone downhill since. Elena was going to her dad's just fine. There was no issues. He was picking them up, dropping them off.
Well,
we arranged.
Elena wasn't part of the problem that Mr. Oakes did. Elena will continue to go there, and you will tell her she will go there.
I have told her, and he hasn't picked her up. She has been staying with her friend because Mr. Oakes has not picked her up. He did not pick her up from her volleyball practice on Tuesday at 5:30.
Are you not wanting to be with Elena anymore?
I am, and in her mother's presence and via text, she said, "I refuse to be with you," and her mom has supported the fact. And
you go to pick her up at the normal times that you're supposed to.
Well, I can't do that if she's not at home.
Well, she will be there for the regular pickup. If she's at volleyball or something, you may have to go pick her up at volleyball. I'm not going to make these kids give up sports and stuff. So that
I wouldn't want that either. I have no problem with that.
It is. I don't know how old you guys are, but you're old enough to figure this stuff out. Mr. Oakes, you got the advantage of Mr. Arnson, who I hold in very high regard. Okay. And
yes, sir.
Ma'am, you don't have the luck of having an attorney. You need to listen to Mr. Arnson on what to do, how to act, and be there, or else things are not going to go good. Okay. Yep. Mr. Arnson, please talk to your client and make sure. I don't know who's at fault. I'm not just blaming him or her, okay? But this has got to stop. This has just got to stop. Your daughter will come over and visit just like regular. I'm not changing anything to do with the summer, ma'am. At this point, it's way too early, and Logan's plenty old enough.
So are you saying the summer can stay as it's been the last 2 years?
Yep.
Okay.
The
last 2 years they've been at my house during the summer.
What I'm saying is it'll be according to the court order. I don't know what it has, but it'll be according to the court order. I'm not changing anything to do with the court order.
Okay.
As far as, sir, if you agreed to do this so that the kids could go to Cedar Springs, I want you to get the kids to the bus stop in the mornings, and you are to get them back to him at the appropriate time, whether it's 6 o'clock or whatever it is, to get them back to him. Okay. There's to be no contact with the two of you unless you can be civil. Otherwise, she will pull up, the kids will get out of the car, and she'll leave. And you're to have no contact with her.
Yes, sir.
All right. I mean, no.
So am I meeting at his location still, or is it okay to meet at a different location?
No, we're going to meet at his location unless there's something more that comes about.
So he's required to stay in the house, though, because that's been the issue, is him coming outside. Okay.
Your Honor, I think a blanket provision of no contact between the parties that pick up and drop off would be appropriate.
Yeah.
I 100% am in agreement with that.
You realize how childish it is? That I have to say no contact between two parents of 3 kids, that they can't have any contact, but I have to. I don't know. What else do we need to deal with?
As far as the summer parenting time, that was never made very clear, and I don't know if that's something that should be.
You want? I'm not going to deal with summer parenting time now. You're so far from summer. You guys can't get along. I'd imagine I'll see you 3 more times before summer. The rate you guys go.
Summer parenting time is in our order.
What is, and follow it. Mr. Arnson will read it to you and follow it. If somebody needs to make a change, you'll file a motion, and if you meet the requisite requirements, probably shade, then I'll have an evidentiary hearing on it.
Your Honor, from a legal perspective, the judgment of divorce references summer parenting time, but it doesn't say what it is. So I was going over that with my client, and it says, you know, the parties, and then they can file a motion to change the summer parenting time, but there's no reference to what it is. And the parties have.
What does it say about parenting time?
What was that, Your Honor?
What does it say about parenting time in the summer?
Let me pull that up real quick.
Well, I'm trying to pull it up myself. Summer parenting time schedule shall continue until June of 2023 at a minimum, and until the further order of the court provided. However, that either party may request the summer parenting time schedule be reviewed by this court upon appropriate motion and notice of hearing. I guess if you want to have an evidentiary hearing regarding parenting time in the summer, we'll set it up. I'll set it some ways out, unless the two of you are going to grow up and figure it out.
Yeah, and that's just the point. I guess the point is that it nowhere in the judgment of divorce it references, but it doesn't say what the summer parenting time is.
I think kind of does through 23 or something, and then after that, parties. So if you guys can't agree on what summer parenting time is, give it a shot. And if you can't, Mr. Arnson, you can contact the office and we can set up a parenting time for summer to have a hearing, and you can spend all kinds of time bringing in evidence and witnesses and all that kind of stuff. All right.
Very good, Your
Honor. I hope, Mr. Arnson, I hope you got enough of what I said to be able to draft the order.
I think I do, Your Honor.
Is there something that we can put into an order as far as our son's education? I was notified by the principal of the school today that he's missed school again today. He now has 38 absences and a GPA of 0.39. He is not going to school.
It's not before me. What am I supposed to do? Order the kid to go to school?
Okay.
I'm just saying, it's not in front of me. It's off the wall. You better figure out what's appropriate for. How old is Logan?
15. He'll be 16 in November.
He's going to end up in front of me as a delinquent, although it'd probably end up in Montcalm. But you got, see, this is the kind of stuff that the two of you don't work together. He knows you don't work together. All this kind of stuff. So he's just using the two of you and your inabilities to be adults.
Mm-hmm.
And he's the one who's going to suffer. Nice job. All right, we're adjourned unless there's anything else, Mr. Arnson.
I'm not aware of anything, Your Honor. I'll submit an order.
All right. Thank you very much. Thank you, Mr. Arnson.
Thank you.
She is supposed to take care.
She should be here. I talked to her yesterday.
But
we kind of came to an agreement, so this should be
out in the internet somewhere. We're just trying to bring her in.
Okay. Yeah, we talked yesterday. We came to an agreement, so this should be.
Oh, please, you're good. I wish I would have brought you in before that, because I haven't had anybody reach an agreement so far today.
I know. I was listening on YouTube, waiting for my turn to come up.
Oh, goodness. In case you didn't notice, I'm going from angry to not so angry to angry again, and you're now putting me in a good mood. So,
well, that's glad I could help there, sir.
We can just get her to connect.
She was having some issues. So we talked earlier today. She was having a hard time. I think she's got a bad internet connection there. So hopefully she gets through here in a second. It's been more than a few moments. Yeah.
Ma'am, can you hear me all right?
Yes, sir.
All right. I'm Referee Frederick. I'm here, and I've understood that maybe you guys have reached some kind of an agreement on this case. Is that correct?
That is correct.
It's a matter of Landon versus Bentley. I have Mr. Landon on Zoom, and Miss Bentley is also on a phone that Mr. Landon has right now, and I can hear her. And it's my understanding that this was a motion filed by Dad regarding custody, but the parties have reached an agreement. Can you tell me, Mr. Landon, what that agreement is?
Yeah. So what we're going to do here is we'd like to keep legal custody the way that it is, so mom can still be part of decision-making process. And then we're going to make me physical custody, or give me physical custody, basically. So
All right.
and me and mom can agree to her parenting time, and we've sort of worked that out. Does that sound right to you, Tina?
Yes, it does.
Okay.
All right. So what the order would read is that the parties will maintain joint legal custody. Physical custody will be to father, and the parties will work together for reasonable parenting time for mother.
Exactly.
Yep.
Does that work out good, ma'am?
Yep. Nope, that's perfect.
Okay, great. We're all in agreement here.
All right, then thank you very much. It's great to have two people who actually figured something out for a change.
All right.
And I wish everybody the best, okay?
All right, thanks. Have a good weekend.
Appreciate
Take
that.
care. Thank you.
Okay,
Versus
thanks.
Ijima. Both parties are present via Zoom. This is a motion filed by the father regarding parenting time, which he has asked for Tuesday after school until 8 o'clock and every other weekend, Saturday to Sunday. He also wants some kind of holiday parenting time. Ma'am, your response seemed to say that you are all right with this sort of arrangement. Is that correct?
Yes.
So he would have every Tuesday from after school until 8 o'clock. This is with Ashlyn, who's 11, I think. And every other weekend, Saturday at what time? Noon or something, or 2, or what?
Well, I usually get out of work around 2, and then I head home, pick up a car, and head over that way. So, my guess would be just like sometime any around afternoon.
You don't get out till 2, though?
Right. Just in case I get out early or something happens.
Ma'am, do you have a problem with saying something like, I don't know, Saturdays at 2 o'clock, or as soon as he can make it?
Yeah, that's fine.
Till Sunday at 8?
Yes, that's fine.
And what kind of parenting time you guys going to work out for holidays? Can you work that out? You should do every other holiday is what you should do. You just trade off the holidays and have the child. I don't know what you work, sir, but if you're not working on, say, the 4th of July, you should probably have the child from like 9 in the morning until 8 at night or something like that.
All right, sounds good. Yeah, we can definitely work that out. Just kind of play it by ear, depending on what family's got what going on.
And that would be great. I mean, if the two of you, I don't know what suddenly happened, because I've now had 2 people that are getting along after having a whole morning of nobody getting along. But let me just tell you, honestly, you two need to get along on behalf of Ashlyn, and both parties should be able to see her on her birthday if you can, and maybe you take turns. Well, Halloween isn't getting to be quite as big a deal or stuff, but even Thanksgiving, and maybe Miss Pike is going to have Thanksgiving meal with her family on Thursday, and so you'll have Friday or Saturday, or vice versa. Or my kids occasionally would go to their moms in the morning and mine in the afternoon, and they'd get 2 huge meals and stuff like that, and that kind of stuff. I really, and Christmas, of course, see, maybe one of you does Christmas Eve with the family, so it'll go there, and the other one, I really hope, let's just put in the order, Tuesdays from after school until 8 o'clock, every other weekend from 2 o'clock, or as soon as father can pick up the child, till Sunday at 8. And the parties agreed to work together on a holiday parenting schedule. Okay. Would that work for both of you?
That's okay with me.
All right. And I'm just going to suggest this, but don't worry about it. When he has a vacation in the summer, if he has a week in the summer, he should have the child for a week in the summer to go on a vacation or something, and work over maybe spring break and stuff like that. If that's the kind of stuff that if you come into me, I'm going to order. Okay? Mm-hmm. I really want both parents to be good parents and have good relationships with the child. All right. So we'll do an order that just gives Tuesday and every other weekend, and that the parties will work together for reasonable parenting time on the holidays. And let's just hope everything works out. All right.
All right. Yes, sir.
Both of you. Actually, nobody wants to say anything bad to the other person, because that's all I've heard all day. Don't you want to say anything bad horrible about him, or about her or something like that?
No.
Yeah, we're all right, man. Appreciate you though.
Hallelujah. Thank you very much. I appreciate the two of you very much today. Thank you. This is my
Self as well. Have a good one.
Thank you. You too. Contact with the Wiccans or whatever comes up. I've had so much contact with them over the last couple of years that. All right, both parties are present via Zoom. This is Ms. Wickens' motion to enforce the judgment. The judgment calls for 50% from each parent for gymnastics, and father's failed to pay since June. Dad said he told her it would no longer be paying because he didn't mutually agree to pay for gymnastics. Anything you want to say, ma'am? Briefly.
Yep, very briefly. This was agreed upon in the judgment of divorce, and Mr. Wickens has failed since June as he believes he no longer has to pay.
All right, Mr. Wickens, anything you want to say briefly?
Just that Ms. Wickens has changed the program a couple different times. She's not in the same thing, and I don't believe that gymnastics is a God-given right.
Is she not in gymnastics?
It's a.
She is.
She's in a. There was a team she was on, then she was on another program. Now she's in another program that has her on the Wednesday that I was supposed to get for parenting time. So
Ms. Wickens is in gymnastics, isn't she?
She's in gymnastics, and the program has changed because Ella has excelled in gymnastics and now competes at a different level.
Well, I had a kid who went through hockey, and he changed regularly, and different things changed on it, but still was in hockey. Mr. Wickens, it says you have to pay for 50% of gymnastics.
It was. I believe it was worded that it was gymnastics and any other mutually agreed upon items, because that was at the time mutually agreed upon. And no, it's
gymnastics is separate from agreed upon. In other words, you were responsible for gymnastics. If she dropped out of gymnastics, you aren't responsible for anything else. If the two of you can't agree that she goes and plays softball instead, then you aren't responsible for that softball type thing. It was the clear reading of the judgment is that you're responsible for gymnastics.
Okay, so that being said, it also said that I was supposed to have equal parenting time and 50-50, and things changed. And since that changed, I'm going to have to pay child support, and I would like that child support to go towards gymnastics because now I'm not going to be able to afford it.
I don't know what I can tell you other than the judgment clearly reads that you have to pay 50%. If you want to try and bring a motion to change everything, I'll listen to it. It's unlikely I'll grant it, but you are paying child support now because you don't have as much time with the child, and that's an issue different from extracurriculars. The only extracurricular that you are responsible 50% for is gymnastics. No other extracurricular stuff are you unless you agree to it. And she's been in gymnastics, I remember, since day one. We've had to adjourn things or do things because she was going to be here or do that or whatever. And that's just the way the judgment reads, is it says you will be responsible for 50% of gymnastics. If you want to somehow come in and say, hey, wait a minute, this is getting out of control, I don't think I should have to pay for it, it's unlikely I'll change your judgment because it's what was agreed to and in the judgment. That's different than child support. That's different than custody, parenting time. Those are always issues for me. But I'll listen to it. If you want to file it, useless though it may be, but the judgment just says you're responsible for 50% of gymnastics. If you want to come in and make a reason why it shouldn't be, then that'll be a separate motion. But as of now, I'm going to grant her order and give you 30 days to catch up.
I will catch up immediately, but I think that you've been very not very understanding lately, telling me that the only way for me to see my daughter is for you to tie her up and have her delivered. And now that I don't get her at all anymore because gymnastics has now changed so that I don't get her on the Wednesday that I could get her because she has practice that day. Miss Wood,
to get her on a different day. How about a different day?
Miss Davidson makes plans on other days. Like my last week, took her to Detroit for a Tigers game and took her camping.
So last week, what?
That was a Sunday. Weekend. That wasn't Tuesday.
On my weekend, she took her camping and then took her to a Tigers game on Sunday. Things that I could be doing with her, but she already had plans set. So Ella decided to go with her mom.
Well, going to Miggy's last game was probably pretty exciting for her.
Yeah, and I would have loved to have taken her there. I've taken her to home openers and all sorts of games. It's something that Ella and I used to share together. She's doing everything she can to have Ella not be a part of my life. And all she cares about is money.
Well, it's like when I introduced the case, you are one of the most frequent people to come here. It is the makes me angry.
I just want something reasonable. This doesn't make any sense to me. I'm losing my daughter, and now it's costing me a lot of money to lose my daughter. If I got to see my daughter,
50% of her gymnastics.
I'm going to tell you this also. Do not plan stuff on his weekends. If I have to issue an order, do not plan stuff on his weekends, then I'm going to do it. If he comes in and says this kind of stuff, you got to just start having her go there on the weekends instead of making other plans. I don't understand why you would even make those plans unless
we were camping with or without Ella.
Camping with her.
With or without her. We were going camping whether she went to her dad's or not. We didn't plan a weekend camping with her, which is a completely separate motion.
I understand. I'm not ruling on
Okay.
anything. I just said if he comes in and you're making plans for things like going to the Tiger game, you have to talk to him about it and stuff like that. You guys got, I'm not going to go any farther because I'm just going to start to get really angry. So you got time to catch up, 30 days. I'll give you to catch up on this motion. It's the only motion that's before me, a motion to enforce. I've just given you some ideas on what I'll do if there are other motions brought, and I hope there aren't. Good luck, everyone. Thank you. We're adjourned.
Thank you.
There was one more thing on there, wasn't there?
Oh.
Insurance.
Oh, insurance. Yeah. I'm sorry. What?
He hasn't been paying her 50% of her health insurance at $67 a month either.
So
did you provide information to him about that?
It's never changed. He's well aware he hasn't paid it in the past 2 months. He just stopped.
Your Honor, did you get my response that I sent in? Okay.
I'm not sure I totally understood some of it.
I didn't get a copy of it.
Last time, all child expenses like medical dental will be included and backdated to the original order date. I mean,
I've dealt with a friend of the court before, and what happened was they backdated everything to when the judgment was put in, and insurance was part of that. So I was assuming that's what was going to be happening now that we have to go through the friend of the court. If insurance is not part of that, then that's fine. But I thought that was something.
Is there a UCSO order? Is there a child support order out there?
I don't have one.
It was supposed to be coming. You said you were going to see it. You were going to review it, and you said you normally don't do it, but you said you were going to take certain things into consideration and make up your own dollar amount as to what I have to pay for child.
Did we send it to the friend of the court for their review?
It already went for review. He bought it, and then he was supposed to send in his income. That was months ago, and I still have nothing.
I have nothing either, and I have not received anything. So I have no problem paying everything current if nothing has been.
Hold on, just a minute here. I mean, because all I have is from something like in 2022.
Right. And he fought that order, and then it had to be reissued through the friend of the court in August, which the lawyer supplied the paperwork, and nothing's been done since. So I have received no money for gymnastics, no money for Ella, no money for her health insurance.
Gymnastics, I understand. He's going to.
And I received no Ella.
I'm trying to find. How much do they say you're supposed to be paying a month? Is it?
They haven't. His income wasn't turned in.
They had set it up that it was like $400 and something a month, but the parenting time wasn't set. That's what we were fighting over, was the parenting time. That's why it was going to be reviewed.
And actually the $400 a month was based on income from 7 years ago because you failed to supply your past 2 years of taxes. So it had to be reviewed again.
Oh, ma'am, just don't cause problems. Best if you just remain quiet for right now, please.
No problem.
I'm going to refer this to the friend of the court for child support. I can't find in here where it was ever finally figured out. I'll call the friend of the court and see what's going on with it, but we'll refer it to the friend of the court. Until then, you'll owe the insurance. You might end up getting credit on it for there, but I'll just refer it to the friend of the court for child support. Both of you need to cooperate with the friend of the court, and we'll get to the bottom of it.
Okay. I've also per your suggestion, I filed paperwork differently 3 different times now, and it's come back wrong.
I don't know.
I was told to ask your advice by the clerk. How do I get? How do I have you enforce the money that she owed me from the sale of our house? That $30,000. There's still $3,400 owed, and I have the proof of it in paperwork. I have proof of every single payment that was made, and I turned that in. It's come back 3 times as that I'm doing it wrong.
I don't know what do you mean you're doing it wrong?
I'd done a motion to enforce.
All right.
And then you had said I had to do it an ex parte order, I believe, and I did that. And then it wasn't you. The judge sent it back that I was filing it incorrectly. So then I went back to the legal help, and they had me file it a different way, and I sent back again that it was incorrect. So
I have no idea what you're doing. So I don't have it here to know what's going on, but I can tell you if you file a motion to enforce, it'll come up to me. You have to set it up for just like any other motion. And God knows the 2 of you have had enough motion practice that you should know what to do. All right. Send it to her and set up a date and time for it. And then it'll come in, and then I'll probably have to have an evidentiary hearing to figure it out. If she denies it, and then we'll set it for an evidentiary hearing, you guys will come in. But I don't know what's being sent back to you. I can't imagine that you would ask to enforce it and ask it in an ex parte order. It would go to the judge, and the judge would almost guaranteed he would deny it, because that's not something that would be for an ex parte order. That has to be both parties have to have time. I really don't know what somebody's sending back to you or anything. If you file a private motion, I'll get it, even if it's a garbage motion.